Welcome to the special immigration show brought to you by Sakshi TV. My name is Ranjit. We are here today with the prominent attorney, Ms. Sheela Murthy, to discuss the latest updates and followed by frequently asked questions. You can call the numbers displayed on the screen and ask any question related to immigration, and our attorney will be glad to answer. We'll start taking calls in a few minutes. Before starting the show, I would like to repeat the disclaimer. Please note this show does not provide any legal advice. It is general in nature and it is informational purposes only. Sakshi TV news and agents are not responsible in any way for your actions. Please use the information at your own risk. For case-specific issues or concerns, please reach out to attorneys for a private consultation. Hi, Ms. Murthy, how are you?
Good afternoon and good evening to our viewers in India. It's great to be here. Thank you, Ranjit.
Yeah, you all know Ms. Murthy is the founder, president, and CEO of Murthy Law Firm and Harvard Law School graduate. Also, she is the one behind the famous Murthy.com website. Before getting into the show, could you please briefly introduce yourself, Ms. Murthy?
Sure. Thank you, Ranjit. As Ranjit just explained, Murthy.com is, of course, the world's most popular legal website. We have oodles and oodles of free information to help you if you're going through the immigration law process, whether it is H-1B or PERM or green card or citizenship, or for family members who are stuck with visa-related problems. Our goal is always to help educate you and empower you so that you do not feel alone along this very complex, difficult, and nerve-wracking process of U.S. immigration law. And Murthy Law Firm and Murthy.com have been providing this free information for over 27 years to benefit the immigrant community. So please feel free to take advantage of it. On top of the website, of course, we have the free weekly Murthy Bulletin. You can subscribe to it for absolutely free. We have the free Murthy Forum with tens of thousands, 80, 90, 100,000 people participating and monitored by attorneys to provide information. And of course, we have this kind of a discussion weekly with Sakshi TV, which is in fact now increasing, I think, to 2 days a week, starting from this week. And then on top of that, we also have the monthly teleconferences and various other free resources, again, to educate you, to enlighten you, to empower you, and to give you the strength that we are all in this together. So please take advantage of these wonderful free resources.
Thanks, Ms. Murthy. Before getting into the show, could you please give us the latest update, and then we can, we have callers waiting.
Yes. So there's nothing earth-shatteringly latest that happened, except earlier today on June 1st, 2021, President Joseph R. Biden declared that the month of June 2021, this month, is going to be National Immigrant Heritage Month, embracing and recognizing that America is and has largely been created as a nation by immigrants, for immigrants, and is a big part of the reason for the success of America as a nation of immigrants. And this is in stark contrast and contradiction to the prior administration, who was, I think, to a large extent, recognizing when 2 of your 3 wives are immigrants and recognizing America as a nation of immigrants, but ignoring it and finding every which way in which to harm or put roadblocks on legal immigrants who are doing everything to go through the process. So this is a wonderful opportunity to embrace and recognize that America is a nation of immigrants. And by all of the different changes that the Biden administration has already introduced in the last 3 or 4 months, whether it is reducing the H-1B RFEs, whether it is recognizing the processing of cases, following the law, following the US Constitution, following their own regulations, finally, we are seeing that sanity and civilization is coming back to the US immigration laws, policies, and systems. So that was really the major change that happened in the past 1 week.
Thanks, Ms. Murthy. We have a caller from New Jersey. Hi, welcome to the show. Please go ahead and ask your question.
Hi, Sheela Murthy. Good afternoon. This is Prabhakar.
Hi, Prabhakar. Welcome.
Hi. I have one question about CSPA, Child Status Protection Act. My daughter has right now 19 years, 5 months. Last year, October, we have filed 485 downgrade from EB to EB3. So what is the option to my child? Can I go for, right now she's on H4, or I'm planning to move H1. Is it better option or can we wait for some time?
I'm not sure I understand. So the child is 19 and a half years old. You filed the I-485 petition application adjustment application back in October of 2020, Prabhakar. And the child is on H4 status. So the child, as you know, is eligible for 1.5 more years until the child your daughter reaches age of 21. She's allowed to be on H4 status. And you're saying that, plus, if the priority dates are becoming current for final action dates, not just dates of filing, Prabhakar, then her age is frozen permanently. She's protected even under the Trump administration change in policy. However, if you're filing it purely based on date of filing and not final action date, then there's a risk that she may not be completely protected under CISPA, the Child Status Protection Act. Now, what Charlie Oppenheim mentioned last week, and what you might have already seen from the US Department of State Immigrant Control Visa Unit, the person in charge of that, Mr. Charles Oppenheim, he has said that they expect a very faster movement of employment-based immigration. That is, most of us know approximately 275,000 immigrant visa numbers will be available in the employment-based category instead of the standard 140,000 for this coming fiscal year to recapture the unused immigrant visa numbers from last year. So hopefully, Prabhakar, she'll be protected, but you will know very soon. At some point, you might want to file her to change her from H4 to F1 if she joins college or university. And even if she's on F1, she can get protected under CISPA and get green card with all of you, as long as we calculate how long the I-140 petition was pending for you and add that time back. And hopefully you did not do a premium processing case. So of course, as Ranjit had explained earlier, we're not allowed to give case-specific advice by law to any person because there's legal, malpractice and other issues. But in general, the rules I'm giving you are in general. Obviously, if you want to, you should consult with your lawyer, consult with the company lawyer. If you don't have a lawyer, you're welcome to call me or contact us at the Murthy Law Firm, and we will be happy to look at it correctly.
Okay. One more question. Actually, my priority date is like 2014 February. Can we expect the final date?
That nobody knows. If it's like saying, can I know which lottery number will win, right, Prabhakar? Nobody knows that for sure. It's going to move, but I don't know which date. That even Charlie Oppenheim, the person in charge in the entire country of moving and working with USCIS to move priority dates, doesn't know that date because it depends on how many cases USCIS processes, how much they can process, how many numbers are unused, and what is being used in both family and employment-based categories.
Okay, got it. Thank you so much. Thank you so much. Yeah.
You're welcome. I hope we can continue to help you, Mr. Prabhakar.
Thanks, Prabhakar. Thanks for the call. Just follow-up question from what Prabhakar is saying. I think he's saying that date is February 2014. I think that's the date retrogressed to Jan 2014 actually. So that's the date. So as per Charlie, I believe he said filing dates most likely could get current. Even if that happens, I believe Prabhakar won't most likely be able to reach February because the current filing dates are only until January. So most likely maybe next year there is a chance. But again, as Ms. Murthy and Charlie have been saying, we don't know yet USCIS how they are going to utilize the numbers. Exactly. I believe there is a lawsuit. Someone is coming up with a lawsuit suing USCIS not to waste the numbers. So let's see if things get better. And Ms. Murthy, if you had looked at it, I believe there is some news going around that President is exploring the options of having the executive action for immigration relief, but we don't know yet which parts they are being considered.
He definitely wants to do something. Maybe that's why he kind of already gave like a hint by calling June 2021 Immigrant Heritage Month in the United States. First time any president has issued an executive order declaring a particular month to embrace the fact that it is focused on immigrants. I agree that he wants to issue more executive orders and he's ready to do it. But ultimately, Congress will have to issue something that's final. But to the extent that there are lots of gray areas in the law, and Joseph R. Biden has absolutely made it clear that he intends to follow the law, but also intends to recognize and embrace that America is a nation of immigrants and recognize the importance that technology, that STEM workers are playing in providing much needed professional help, whether it is to large companies, to federal or state governments, or within the US economy in the medical and healthcare fields during COVID-19, during the pandemic. I think it's extremely valuable and important that this executive action has just been released, declaring this month, which has got all of the issues that he's talking about, making and recognizing and embracing a lot of changes that are proposed, including the first day that he came into office on January 20th of 2021, when he suggested and asked Congress to pass the USA Citizenship Act of 2021, because that actually talks about recapturing the unused immigrant visa numbers of a lot of the things that employment-based immigrants are seeking and desperately need.
Thanks, Ms. Murthy. We have another caller, Vishwanath from Texas. Hi, Vishwanath. Welcome to the show. Please go ahead and ask your question.
Yeah, sure. Thank you, Ms. Sheela. It's great to see you on TV. Great to hear from you. My question is very simple. There are thousands of immigrants in U.S. Who have their legal visas here, and they are staying here. And the current immigration process says that you have to periodically go back to your country and stamp your visa again and then come back. I mean, Murthy Law Firm is such a big one, and I'm sure your voice counts a lot than any other person here. So I felt as an individual here in the U.S. that it doesn't make any sense that people have to go back to their country to get a U.S. visa here. Do you believe that this can change? And is Murthy Law Firm able to do anything about this to the government here?
Thank you, Vishwanath, for your question, for your comment. I appreciate it. And we certainly want to, have been responding and in fact provided very strong comments with respect to removing barriers to legal immigration. But just so I make this very clear, Vishwanath, there is nothing under US immigration law which requires any person who is physically, legally in the United States to have to step out of the United States to get a visa stamp from abroad just to come back. Now, if you anyway want to go to visit your family or your friends or for a wedding or some other personal family issue, and you don't have a multiple entry visa stamp in your passport, then the person is required to travel abroad to apply for a visa stamp in the passport. Otherwise, for example, if you have a 3-year H1 approval, Vishwanath, and you get another extension of 3 more years, and then by the time your employer has filed your PERM or labor certification or I-140 approval, you can get another 3 more years and 3 more years of H1 extension within the US. You do not need to step out of the US to stay legally, to continue to work legally, and to stay here until you get your green card, which could take 5, 10, 15, 20 more years. But there is absolutely no legal requirement to step out of the US. The only requirement is when the USCIS determines that a person has violated the status, is not maintaining valid legal status, then they will approve the H1 without the I-94 card attached to the bottom of the approval notice, right? Because they cannot grant you the extension because they're saying you're not in status. Only in those cases is the employee, H1B worker, required to go out to clean up the having fallen out of status issue. Otherwise, there is no legal requirement under US immigration law for anyone to step out of the US.
Thanks, Ms. Sheela. But, you mentioned those reasons where we have to travel outside and get the stamp. And one of them being like if we have to visit parents or friends back in India, for example, to get the stamp. But, when I'm in your country as a foreigner, isn't it easy just to give me an extension along with the stamp and passport here? Why are people have to get the stamp elsewhere, which belongs to your country, and I'm in your country already? Why should people get stamped there rather than just getting stamped here, even for renewals and everything, even if I have to go to visit somebody?
Yeah, so before we used to do that, it used to be called automatic visa revalidation, the AVR rule. It used to be done prior to September 11th. 2001, Vishwanath. It was routinely done where we would just send the passport when the visa stamp got renewed. We would send it to Washington, D.C. and get it renewed. But unfortunately, what happened, because those crooks, the hijackers, the thugs really messed it up by doing criminal and illegal activities, and they were granted visas. They didn't want people like that to be able to terrorists and other people. So the requirement under the Homeland Security Act and other federal legislation was every few years, make sure that if someone steps out of the US, because why are they going out? If they're trying to come and, gather whatever, do illegal things abroad, we want to be the consular officer, US consular officer is required to look the person in the eye, interview them, ask them what they've been doing with their time, either abroad or in the US. So you make a valid point. It is how it always was for decades, for centuries, where we were always able to do the visa restamping or revalidation within the United States. But after September 11, the entire country changed. Our entire legal system changed. Immigration was no longer part of the US Department of Justice. We switched to US Department of Homeland Security, Vishwanath. Everything became about security, protecting the homeland, making sure that we would not be bombed out of existence, which is, I think, reasonable. And as happened in India, after the November incidents in Mumbai, that India's version of 9/11, November of, I think the following couple of years later, their whole laws in India also have similarly changed. So it's required for protection of the country. So at this point, I would say it is what it is at this point. You make a valid point and the government says, then don't step out, call your family to visit, call your friends to visit, but don't go out, because if you go out, we have the right by law and we are required by law to interview you in person. Now, remember this also, Vishwanath, according to the latest policy, the US Department of State allows you not to attend a personal interview. You can mail your documents through the travel.state.gov. And as long as your visa has not expired for more than 48 months ago, which is 4 years, within the past years, you don't need a visa appointment or an interview to get stuck. In majority of the cases, you can just mail it and they are mailing back the approvals, unless they have fraud issues, security issues, or they believe you're not eligible anymore for the H-1 because of various reasons under the law.
Thanks. I hope that answered your question, Prabhakar. Ms. Murthy, coming back to the same question. A lot of people are being struck in India, and there is no actually science behind it. It's just because people are from India, they are just restricting them. Rather than, a lot of people say that go with the scientific approach rather than just excluding US citizen kids, parents, or whoever, rather than allow people who are vaccinated, allow people who have a negative test as well as a 2-dose vaccination. How do you think, science, on science basis, is it better, or do you think it's better the way it is now?
So of course, science always triumphs, and Joseph R. Biden has made it very clear, our president, that he absolutely believes in science and follows science. I think there is concern, by the way, just FYI, it's not India alone. It's most of the Schengen countries, most of Europe. In fact, United Kingdom, just earlier today, I got a desperate call from somebody who is stuck now for 2 or 3 or 4 months in London, who's a British citizen, British national, born there, grew up there, Caucasian, who works with a major, sort of quasi nonprofit in the New York area. And he's stuck there because he did not read the rules that if you are from any of the countries which had any spread of the COVID-19 pandemic, they don't want you to come back unless you get what's called the NIE, the National Interest Exemption, where you have to show that your work benefits the United States as the national interest exemption, that it is in the critical infrastructure or health reasons, you're in medical professions, or why and how your work benefits the US and the national interest to make an exemption or exception for you. So trust me, many countries, including China and Brazil and Schengen countries, Europe, UK, Ireland, all of them are dealing with the same situation. Even this person has a valid had a visa stamp in the passport, has an approval, it was confirmed by the employer, can and should be able to come back, but isn't able to re-enter because the airline sent him back outside the flight. Do I agree with it? No, because it doesn't make sense, but there are the CDC, the Centers for Disease Control, and various federal agencies have really researched and studied how can we deal with and protect Americans in America so that the disease, the pandemic doesn't spread. And so they're saying that for countries that have had either a variant like the UK variant or the Indian variant, they are just trying to be extra cautious. So even if you have a visa stamp in your passport, that doesn't mean you can come back. In fact, the airlines are now routinely turning people back from the airport if they are not convinced that you have received the NIE to be able to travel at this time. So travel at your risk, or travel if you know you can stay for months and months or years abroad, because until the pandemic is under control, no country in the world, India had locked people from US coming at the beginning, if you remember 1 year ago. India had shut down all flights from every country in the world. Every country in the world will do what it needs to do to protect its citizens. I do not have the same level of in-depth knowledge like the experts in medicine, in science, in technology, in even what's required. And they are making exemptions. But remember also, consulates by and large are closed or using minimal operations because of COVID-19 for personal interviews. And some of these by law are required to go through a personal interview. They are making exceptions for F1 students that was just released, M1 students, J1 students, whose course classes are starting in August. If your class is starting on August 1, 2021, or somewhere in August or September, then you are automatically presumed to have received an exemption and can apply for the visa. And if you have the visa, then you're able to travel back on that visa. But other people who don't have the NIE exemption or waiver, national interest exemption waiver, will unfortunately have to apply for it.
Yeah, I understand, but the main thing is, as you're saying, UK and other Schengen countries are also banned. Comparatively, there are about 1 million or more immigrants, Indian nationals in America, and coming back and forth from India is relatively higher than that of other countries, especially in terms of the employment base. That's one thing that a lot of people of India are being suffered. We have another caller, Jayesh from Pennsylvania. Let's take the call. Hi, Jayesh. Welcome to the show. Please go ahead and ask your question.
Hello.
Please go ahead, Jayesh.
Good morning. I'm Joshua speaking.
Hi,
yes,
George.
please go ahead.
Hello.
Yes, please go ahead. We can hear you.
Yeah, my son is studying in the Penn State University, graduation there. He's in first year, and his visa is going to expire in next month. Due to this pandemic, he is unable to come to India and renew his visa, study visa. So what should he do, and when he can come, and when the pandemic and all the air... what I mean is that the flights, when they go on from India to USA, then he can renew his visa, or is there any problem before that?
Yeah, I don't know why. He doesn't need a visa, as I explained earlier, George. He doesn't need a visa to continue his education. If his I-20 is valid, his F1 status is valid, as long as I-20 has not expired, even if the visa stamp in the passport has expired, that has nothing to do with being able to continue his education and studies. So again, I don't know if some people use the word visa and status interchangeably. Visa is a very technical term. So make sure that if it's only the visa that is expiring, the F1 student visa stamp in the passport, then there's no problem. As long as the I-20 is valid and endorsed, he's continuing his education, and he's following all the rules, and he's maintaining his grade point average, and hasn't been in violation of status, has been attending classes virtually or physically, there shouldn't be a requirement by law for him to travel to any part of the world. He can stay here and continue his education, George.
Thanks for the call. A lot of people are asking this question. I just wanted to get it confirmed with you. You know very well that last year, when the filing dates have become moved a lot for a lot of people, they were not able to apply for the spouses who were stuck back in India. Now, a lot of people are asking, everyone knows that you cannot file later when the filing date is current, but let's say their priority date is current now. Uh, can they now add spouses or the family members under the age 21? Is that possible?
So if the spouse, it isn't clear from the question if the spouse is still abroad or in the United States.
In the US, let's assume they came back, now they want to add.
If they came back, of course, they immediately can file the 485. If the priority date is current, absolutely, 100% they can file the 485 for the spouse and all minor children below the age of 21. And even if they're abroad, by the way, we have to do what's called, as soon as the principal's green card is approved, you can file the I-824 to notify with the same employer who filed the I-140 petition to request the USCIS for the family members to get the immigrant visas from abroad. And there is some argument that under the CISPA, the Child Status Protection Act, that as long as the I-824 is filed within 1 year of the priority date becoming current, that arguably the age of the child can be frozen under CISPA for CISPA purposes for the child to enjoy the benefit. Again, remember, CISPA looks like a very, very simple law, but it's got some nuances that are very tricky. But whether they're in the US, it's so easy. That's a no-brainer. Just file the 485, EAD, AP, everything for the spouse and all children. They should be covered and protected, because if they came in on H4, as long as we file the 485, even if the principal gets it much before because it was filed months before, no worries. The family members are allowed to stay based on a period of authorized stay based on the 485 filing.
I believe this is the case, even though the principal has got their EAD and AP and everything, just the green card is not approved.
Correct. If the green card is approved, then we have another much more complicated problem, because then the family members are no longer permitted to re-enter on the H4 dependent status because the principal is now a permanent resident. Then it makes it much more complicated, because then you would be abroad and do what I just explained, that whole 824 process, get that approved, pick up the immigrant visa, the way you got the H1 visa stamping in your passport or H4 visa stamping. Family members will have to apply for the immigrant visa stamping and get that from abroad, from either Delhi or Mumbai, and enter the United States after the immigrant visa is issued, which, by the way, under the priorities of the Biden administration, after US citizens, immigrant visas are next. They are putting that on high priority, and then non-immigrants are third after that. So absolutely, there are options any which way. If your company lawyer or business lawyer or family lawyer is not aware of what to do, then please consult any lawyer who knows the law. And if you are not familiar, don't hesitate to contact. You can do a lot of research for free on murthy.com, but if you'd like to schedule a consultation, please do so with an attorney by writing to law@murthy.com.
Another question, Ms. Murthy, is this the case even, let's say, someone's GC just got approved and he wants to get married and, get the wife? How does it work? Can they go to consulate?
No, because for green card, now he has to file, this person, he or she, the person who got the green card has to file the I-130 petition. Luckily, the priority dates are current for a family-based second preference 2A category. So the person can then file the immigrant petition, and within a year when it gets approved, they will schedule the immigrant visa for the spouse to enter. So I tell people, do not file the 485 if you're about to get married, because if it gets approved, you are in deep trouble. You're better off flying to India, getting married and coming back and bringing your spouse on H4 rather than trying to get this approved and now being separated for 1 or 2 years while the immigrant visa processing is going on.
Thanks, Ms. Murthy. Another question a lot of people have is, it's a quick question. So let's say the H1B 6 year is maxed out, and I know there is a one year cool off period, but then within that 1 year, let's say if they have got the I-140, the perm started and I-140 got approved, do they still have to go through lottery, or because now they have 140 approval, they can just become cap exempt?
You're cap exempt. If you ever had an H1 before, you have an I-140 approval. Even in the future, if you were in the middle on some other status like B1, B2 or F1 or whatever you did, you can now get another 3-year H-1B extension. As long as you're maintaining valid non-immigrant status, NIV status in the United States, you are allowed to now file a change of status or an extension if your H-1 is still valid for 3 more years, and you are not counted against the quota or cap.
Doesn't matter if the perm or labor has started before the 6-year maxed out.
It has to start before the 6. It doesn't matter. Ultimately, it doesn't matter because it could have been done anytime, as long as the reason people do the 6th year, the 5th year to file the perm is because if the firm is filed and pending more than 365 days, then you get the 1-year H-1 extension. Otherwise, you get, based on I-140 approval, you can get the 3-year H-1 extension, right? So that's why we talk about the 1 year filing everything, at least, preferably starting it at least 2 years before your 6 years are over, to avoid a gap in status or being forced to switch to B2 tourist status or being forced to switch to F1 student status.
Thanks, Ms. Murthy. We are towards the end of the show again. Thanks everyone for the calls and watching the show. It was a great session with interesting topics and questions. Please call in every Tuesday at 3 p.m. EST to watch the special immigration show with Ms. Murthy. Again, it's every Tuesday at 3 p.m. EST. This is Ranjit signing off. Thanks, Ms. Murthy.
Thank you very much. Bye-bye.